Let's go to Sandra in Tampa. Hey, Sandra.
Hi. Hi. I owned a house with my deceased ex-husband. Does that mean that I now automatically own half of the property and the other half is in my children's names?
Okay, so you said deceased ex-husband.
Right.
So he owns half, his estate owns half, and you own half.
Right. That's been probated, and now it's in my children's names.
Okay. Okay.
That was my question, but does that mean that I automatically own half of the property?
Yeah, well, if you owned half anyway, or you owned it jointly, the divorce would make it 50-50. Because even if the deed said jointly between you and him with right of survivorship, that right of survivorship upon divorce made it tenants in common, which means you own half outright and his estate owned half. So if his estate's been probated, then that half went to his children. So now you're co-owners with the children.
Okay. The other half is now listed on the children's deed as tenants in common.
Right.
By my two adult children.
Right.
Does that mean that there are now two deeds on this property?
No, there's just one deed with two owners.
One deed with two owners. Okay. One of my children lives in the house. Can the other child simply quit claim his ownership to the other sibling, or is it more complicated than that?
No, that would work.
And may I simply quit claim my half of the interest in my property to the child who lives on the property?
You could. You don't live there yourself?
Oh, no.
Okay. Yeah, you got to be careful, though, because a quitclaim deed is a gift. And so the property should be appraised to put a value on it. And the value of the gift has to be reported on a 709 gift tax IRS form. And that would establish a gift. If the gift value is more than $15,000, then you have to file a gift tax return. There would not be a tax if you elect not to pay the tax and use up part of your lifetime exemption. And your lifetime exemption is $11.4 million.
Okay. Now, that would implicate me as far as being eligible for the Medicaid, right?
Yes. Yeah, that would be a Medicaid implication to your gift if you did that.
For 5 years. Okay. And my deed didn't say anything about joint survivors or whatever.
Well, did the deed just say your name, his name, husband and wife?
It. Yes.
Okay. Well, that husband and wife means tenants by the entirety on that deed. So upon the divorce, that became tenants in common automatically. So
I'm also tenants in common.
Yes, you have an undivided 1/2 interest in the house, and your two kids have one undivided 1/2 interest.
But there would be no problem with me quit claiming it over to my son.
Except it would be a gift.
It would be a gift. Okay, well, thank you so much.
All right, thank you.